Welcome back to the Making International Law in Korea, the video series. In this video, I'll be explaining to you on Korean Armistice Agreement. When North Korea invaded South Korea on June 25, 1950, it was clear from a legal standpoint of view that the war has begun between the two nations. A large-scale hostility in the peninsula lasted for 3 years and ended when Korean Armistice Agreement was signed in 1953. The parties agreed to hold another conference at a later date to finalize peace agreement and to abide until that time by the terms of the armistice. Since the parties has thus far failed to finalize a peace settlement, the effect of the armistice on the legal status of conflicts and the applicability of law of war are ambiguous. The title of this agreement is Armistice, but many documents use the term of truce and ceasefire as well throughout the negotiation. For example, a UN document written in a meeting in July 1951 used the expression and concrete the arrangement for ceasefire and armistice in Korea. This document, named Memorandum by the Counselor Bowen to the Secretary of State, written in October 1951, used the expression truce talk. The Commander-in-Chief of the United Nations, Matthew Ridgway, even used those three words without distinction. It is difficult to distinguish among those three terms, and especially truce and armistice are almost used as a synonym. Armistice is stipulated in Law and Customs of War on Land, 1907, and Regulations concerning Law and Customs of War. Regulation Chapter 3, which is the flag of truce, utilizes truce as a procedure to initiate negotiation, while Regulation Chapter 5, which is the armistice, utilizes armistice as an actual commitment of suspending the hostilities. Armistice, therefore, traditionally means suspending hostilities temporarily and provisionally so that it cannot have an effect to put a termination to the war itself. Actually, aforementioned treaties have the implication of a possible resumption of hostilities. Many scholars have defined the legal status at war of the Korean Peninsula based on this traditional approach of armistice. The Commander-in-Chief of the United Nations, the Matthew Ridgway, sent a message about peace talk on June 30th in 1951, and China and North Korea promptly replied that the Central Party allowed the suspension of hostilities to occur, held a peacemaking negotiation. This is an example of China and North Korea intentionally interpreting such an agreement to exceed the spectrum of the traditional approach of armistice. The preamble sent from the Commander-in-Chief Ridgway to Chairman of the Joint Staff of the United States stated, "A mutually agreeable agreement may be reached on military terms for terminating the armed conflict in Korea. The objective of the United Nations forces stipulated a cessation of hostilities in Korea and assurance against resumption of fighting." Also, draft statement of the policy proposed by the National Security Council on United States objective and courses of action in Korea stipulates that the United States objects to terminate hostilities under appropriate armistice agreements. The Security Council also mentioned that it notes with approval the conclusion of armistice in Korea and expresses profound satisfaction that hostilities have been brought to an end on terms acceptable to the United Nations. Therefore, the Korean Armistice Agreement aimed to complete the suspension of hostilities an armed conflict in Korea. This is a point that can be distinguished from the traditional approach of the armistice. In other words, armistice perceived in traditional approach provide the room where the hostilities may under certain prerequisites resume, while emerging views do not. United Nations may have sought a completely new war be waged if Communist Chinese army got a large-scale attack in violation of the armistice. Furthermore, Article 26 of the South Korean criminal law stipulates that the time at a war is the duration of the declaration of war or taking hostilities against counterparts until the establishment of truce. Article 77 of the Constitution stipulates that President can declare the martial law in cases of national emergency, but the previous presidents of many generations have not done so on usual circumstances. Consequently, it may not clear whether current legal status of the Korean Peninsula is in a state of war or not. Anyhow, continuous tension in the Korean Peninsula has interfered with the building peace regime. Let me move to Inter-Korean Basic Agreement. It is unparalleled in history that the status, which neither war nor peace, continued for more than 60 years. The Korean Armistice Agreement in 1953 had made the war ended, and then Inter-Korean Basic Agreement on reconciliation, non-aggression, and exchange and cooperation between the North and South in 1991 intended the peace building in Korean Peninsula. A joint declaration by North and South Korea in 1974 stated that Korea should pursue peaceful unification and democratic system without interference by the third party. Inter-Korean Basic Agreement is a process toward the peaceful unification, which is accomplishing the ethnic reconciliation through removing the state of political and military confrontation, avoiding armed aggression and hostilities, reducing tension, and ensuring peace. The 25 clauses of the Inter-Korean Basic Agreement are subject to three categories. There are reconciliation, non-aggression, and exchange and cooperation between two Koreas. The first three regarding reconciliation, to recognize and respect each other's system, not to interfere in each other's internal affairs, and to transform the present state of armistice into a solid state of the peace. And secondly, regarding non-aggression, not to use force against each other and to resolve dispute peacefully through dialogue and negotiation. And lastly, regarding exchange and cooperation, to promote free intra-Korean travel and contacts and to reconnect the landlord and lord. The way the arrangement was adopted toward peaceful reunification is evident in the term special interim relationship of the preamble in the Inter-Korean Basic Agreement. It means that the Korea questions are distinguished from other international relations issues in terms of ethnic unity and reunification. But so far, the Supreme Court and Constitutional Court of South Korea have constantly denied the legally binding force of this Inter-Korean Basic Agreement with many reasons. For example, as a gentleman's agreement and intentional prevention of binding force upon drafts or the lack of domestic process for ratification. North Korea also changed its approach to the agreement by denying the agreement legally binding force. The North Korea made a declaration nullifying the Inter-Korean Basic Agreement and its annex agreement related to NLL, Northern Limits Line. It claimed that the South Korea did not implement the June 15th declaration and October 4th declaration properly. It is unorthodox for the North and South to maintain the denial of the document's legal force, while both Koreas has agreed on the form of the documents about rights and obligation toward peaceful reunification. Also, their argument that this inter-Korean-based agreement need to be ratified under the Constitution of South Korea, Article 60, Paragraph 1. An agreement of ratification in the National Assembly should be distinguished with the legally binding force of the Inter-Korea Basic Agreement. Even if the Inter-Korea Basic Agreement needs to be ratified in the National Assembly, reporting in a National Assembly makes it effective based on practice. Some argue that the Inter-Korean Basic Agreement is more likely an agreement in a simplified form, such as executive agreement in the United States. Overall, the both Koreas recognize each other as the enemy and special interim relationship at the same time. Therefore, atmosphere in Korea have frequently changed from intention to friendship and vice versa.